8.6 Reclassification of lands. Fordic v. Corona. Facts. Concerns the MR of the court's resolution dated November 17, 1998 and motion to refer the case to the court en banc. In previous case, the court voted 2-2 on the separate motions for reconsideration, as a result of which the decision was affirmed. The court noted in a resolution dated January 27, 1999 that the movants have no legal personality to seek redress before the court as their motion to intervene was already denied and that the motion to refer the case to the court en banc is akin to a second MR which is prohibited. In this motion, both respondents and interveners prayed that the case be referred to the case en banc inasmuch as their earlier MR was resolved by a vote of 2-2, the required number to carry a decision under the Constitution was not met. Issue 1. Failure to meet the 3 votes justifies the referral of the case to the court en banc. Held no ratio. A careful reading of the constitutional provision reveals the intention of the framers to draw a distinction between cases, on the one hand, and matters, on the other hand, such that cases are decided while matters, which include motions, are resolved. Otherwise put, the word decided must refer to cases, while the word resolved must refer to matters, applying the rule of redendo singula singulis. With this interpretation, it is clear that only cases are referred to the court en banc for decision whenever the required number of votes is not obtained. Conversely, the rule does not apply where, as in this case, the required 3 votes is not obtained in the resolution of a Mr. Hence, the second sentence of the provision speaks only of case and not matter. The reason is simple. Article 8, Section 4 pertains to the disposition of cases by a division. If there is a tie in the voting, there is no decision. The only way to dispose of the case then is to refer it to the court en banc. On the other hand, if a case has already been decided by the division and the losing party files a MR, the failure of the division to resolve the motion because of a tie in the voting does not leave the case undecided. There is still the decision which must stand in view of the failure of the members of the division to muster the necessary vote for its reconsideration. Quite plainly, if the voting results in a tie, the motion for reconsideration is lost. The assailed decision is not reconsidered and must therefore be deemed affirmed. Such was the ruling of this court in the resolution of November 17, 1998. Issue 1. The referral to the court en banc is justified on the ground that the issues are of first impression. Held no ratio. The issues presented before us by the movants are matters of no extraordinary import to merit the attention of the court en banc. The issue of whether or not the power of the local government units to reclassify lands is subject to the approval of the DAR is no longer novel, this having been decided by this court in the case of Province of Cameron Sur, et al.vs. Court of Appeals, wherein we held that local government units need not obtain the approval of the DAR to convert or reclassify lands from agricultural to non-agricultural use. Moreover, the decision sought to be reconsidered was arrived at by a unanimous vote of all 5 members of the Second Division of this court. Stated otherwise, this Second Division is of the opinion that the matters raised by movants are nothing new and do not deserve the consideration of the court en banc. Thus, the participation of the full court in the resolution of movants' motions for reconsideration would be inappropriate. Issue 1. The referral to the court en banc partakes of the nature of a second MR. Held yes ratio. The contention, therefore, that our resolution of November 17, 1998 did not dispose of the earlier MR of the decision dated April 24, 1998 is flawed. Consequently, the present MR necessarily partakes of the nature of a second motion for reconsideration which, according to the clear and unambiguous language of Rule 56, Section 4, in relation to Rule 52, Section 2, of the 1997 Rules of Civil Procedure, is prohibited. True, there are exceptional cases when this court may entertain a second motion for reconsideration, such as where there are extraordinarily persuasive reasons. Even then, we have ruled that such second MRs must be filed with express leave of court first obtained. In this case, not only did movants fail to ask for prior leave of court, but more importantly, they have been unable to show that there are exceptional reasons for us to give due course to their second motions for reconsideration. Stripped of the arguments for referral of this incident to the court and bank, the motions subject of this resolution are nothing more but rehashes of the motions for reconsideration which have been denied in the resolution of November 17, 1998. To be sure, the allegations contained therein have already been raised before and passed upon by this court in the said resolution. Issue 1. The win-win resolution was valid, held no ratio. This refers to the resolution by authority of the President modifying the decision dated March 29, 1996 of the OP through Executive Secretary Ruben Torres. NQSRMDC's application for conversion is approved only with respect to 44 hectares as recommended by the DA. The remaining 100 hectares found to be suitable for agriculture shall be distributed to qualified farmer beneficiaries in accordance with RA 6657. The resolution is void and of no legal effect considering that the March 29, 1996 decision of the Office of the President had already become final and executory even prior to the filing of the MR, which became the basis of the said win-win resolution. While it may be true that on its face the nullification of the win-win resolution was grounded on a procedural rule pertaining to the reglementary period to appeal or move for reconsideration, the underlying consideration therefore was the protection of the substantive rights of petitioners. Just as a losing party has the right to file an appeal within the prescribed period, the winning party also has the correlative right to enjoy the finality of the resolution of his/her case. In other words, the finality of the March 29, 1996 OP decision accordingly vested appurtenant rights to the land in dispute on petitioners as well as on the people of Bukidnon and other parts of the country who stand to be benefited by the development of the property. Before finally disposing of these pending matters, we feel it necessary to rule once and for all on the legal standing of interveners in this case. In their present motions, interveners insist that they are real parties in interest inasmuch as they have already been issued certificates of land ownership award, or CLOAs. And that while they are seasonal farm workers at the plantation, they have been identified by the DAR as qualified beneficiaries of the property. These arguments are, however, nothing new, as in fact they have already been raised in interveners' earlier motion for reconsideration of our April 24, 1998 decision. Again, as expressed in the opinion of Mr. Justice Martinez, interveners, who are admittedly not regular but seasonal farm workers, have no legal or actual and substantive interest over the subject land inasmuch as they have no right to own the land. Rather, their right is limited only to a just share of the fruits of the land. Moreover, the win-win resolution itself states that the qualified beneficiaries have yet to be carefully and meticulously determined by the Department of Agrarian Reform. Absent any definitive finding of the DAR, interveners cannot as yet be deemed vested with sufficient interest in the controversy as to be qualified to intervene in this case. Likewise, the issuance of the CLOAs to them does not grant them the requisite standing in view of the nullity of the win-win resolution. No legal rights can emanate from a resolution that is null and void. Mellow by mandate of the Constitution, cases heard by a division when the required majority of at least 3 votes in the division is not obtained are to be heard and decided by the court and bank. The deliberations of the 1986 Constitutional Commission disclose that if the case is not decided in a division by a majority vote, it goes to the court and bank and not to a larger division. In a situation where a division of 5 has only 4 members, the 5th member having inhibited himself or is otherwise not in a position to participate, or has retired, a minimum of 3 votes would still be required before there can be any valid decision or resolution by that division. There may, then, be instances when a deadlock may occur, i.e., the votes tied at 2-2. It is my humble view that under the clear and unequivocal provisions of the 1986 Constitution, if the required majority is not reached in a division, the case should automatically go to court en banc. I submit that the requirement of 3 votes equally applies to motions for reconsideration because the provision contemplates cases or matters heard by a division. And a motion for reconsideration cannot be divorced from the decision in a case that it seeks to be reconsidered. Consequently, if the required minimum majority of 3 votes is not met, the matter of the motion for reconsideration has to be heard by the court en banc, as mandated by the Constitution. To say that the motion is lost in the division on a 2-2 vote, is to construe something which cannot be sustained by a reading of the Constitution. To argue that a motion for reconsideration is not a case but only a matter which does not concern a case, so that, even though the vote thereon in the division is 2-2, the matter or issue is not required to elevate it to the court en banc, is to engage in a lot of unfounded hair-splitting.